Hi, everybody. This is Arkady Frekhtman. I'm a New York City personal injury trial attorney, and welcome to Raw Law. This is the show where we answer your questions and we talk about your comments. It's all about you, the viewer, on this episode. So what we're going to do is we are just going to, answer people's questions from the comments. We're completely live. I'm in my office in Brooklyn. This is an interesting week. It's a little bit busier than usual. I was supposed to start a trial on Monday and I was ready to go. But what happened was I have a co-counsel on the case. It's actually Richard. You probably maybe remember him. We did some videos together. He's in our Bronx office. We're going to do the case together. And we needed like maybe a few days, and the defense lawyer needed a few days because they hadn't done their subpoenas and other things. So anyway, the trial is now going to be June 11th. So it's pretty short, but just we have a few days, and it's actually really good because now we can get all the finishing touches done. Like, for example, I want to do like a medical timeline that's very visual, like with the name of the provider, but also a photo and then the date of treatment. So you can kind of show the jury, because this particular client that we're going to trial on, she had a lot of treatment. It's a traumatic brain injury case, and she had so much treatment that it's from 2015 until now, so 10 years of treatment, and there's like hundreds and hundreds of visits. So I don't want to make it overwhelming. I want to make it visual and just say, look, there's this hospital, there's this doctor, there's this neuropsychologist, neurologist, neuroradiologist, here are the scans, here's the, whatever it was, and then how many dates. Like, for example, she went to NYU and there's like 100 visits at NYU, and just make it simple, very visual. So it'll be cool. So I'm going to work on that. So yeah, let's get into the question. So here's the first question from Virgo Vibes. And she says, my lawyer has filed my lawsuit. I've already collected my medical bills, records, and liability evidence. Will this help speed up the production of documents and discovery process? Yes, since you already have all that. So when the defense lawyer asks for that, then the lawyer already has it, right? So she can just produce it. So she won't need to spend extra time on that. So that's a good thing. So yeah, for sure. Okay, and then Gatry asks, hello, Mr. Arkady, how did your trial went? Yeah, so I was just talking about that. So it didn't start yet, but we're trying to, also maybe we could settle the case. Although right now we're kind of far apart. The settlement went like this, basically. I proposed, they have 6 million in coverage, right? They have 1 million with a 5 million excess. The offer on the case is like 120,000, and it's been the offer for like 5 years. So I said, look, pay me 4,750,000, but that was due May 9th. And if you do, we'll accept that. It was like one of these settlement opportunity letters, the way I like to do it, right? I gave them the opportunity, and now the ball is in their court, and they have the opportunity or the choice to make, right? So they had until May 9th. They didn't take my opportunity. They did not agree to 4,750,000. In fact, they let the opportunity elapse. So it's like the deadline passed, right? And then I think it was like May 11th or May 12th, they sent me an email and they're like, oh, we're going to increase it from 120 to 250. So now the offer is 250,000. But remember, my letter, my original letter said, pay me 4,750,000 by May 9th at 5 p.m. Eastern Standard Time. If you don't pay it, the minimum amount I will accept is going to jump to 7,500,000. So as soon as I saw that email from them saying it's 250 now, I said, look, you're going in the right direction, but you're still 7.25 million short. So either pay that, or once I start picking a jury and I'm actually engaged in the trial itself, it's not even going to be 7.5 anymore. At that point, it's going to be 10. So you see how I do it? I just go like full steam ahead. I'm like a train. I just go full steam ahead. I don't play with them. See, what they want you to do, these insurance companies, is they want you to like start saying like, oh, 6 million is so high. Can you give me 5? Can you give me 4? Can you give me 3? They want you to go down, and then that's their goal. They want to drag you down into like this dungeon or whatever, right? And get you to settle for the lowest possible denominator, the lowest possible amount. And then you settle for pennies on the dollar. But I do it the opposite way. I do my Arkady style, That's why, some people say the people's champion. I'm trying to do good for the people. So I just go full steam ahead. Now, look, if they start playing fair and they say, here's 5 million offer, it's up to the client. The client might want to take it, right? It's a lot of money. But at least I'm not going to play their game. I just go full steam ahead. I'm ready for trial. So let me go back to the questions. Okay, Jose says, can the defense also sue their own insurance company for bad faith? Yes. I mean, the way that works is not the defense, but the policy holder, right? Because remember, the duty is to the policy holder, the person that has the policy, also known as the insured. So if the insured, for example, tells like State Farm or Allstate, hey, tender my 100 policy, I don't care. I'm just paying my premiums, right? I don't care about my 100 policy or whatever I have, a million policy. Tender it because I don't want to come to court. I don't want to get cross-examined. I don't want to be there in trial, right? But then they say, well, no, we don't care. We're still not going to pay because we want to save our money and we don't really care about you, the policyholder. Well, that's when, if the verdict then comes in and it's like 100 policy, let's say, for example, only 100,000, right? And then the verdict comes in and it's like 1 million. But wait a minute, you had a chance to settle for the 100, but you chose not to. Well, now this insurer, this policyholder that I'm suing, John Smith, let's say, he can then assign his rights to sue his own carrier to me, and then I could sue the carrier through him. That's how that works with bad faith. Okay, and then Maddie says, hello, Arkady. I'm going to mediation, but haven't done a deposition. Why is that? Well, mediation could be at any time. Mediation is an attempt to settle the case, right? It's a negotiation. So you have a judge, you have the other side, and you just talk turkey, like, about the case. So usually mediations are done after depositions, but they don't have to be. So you could do a mediation at any time. You could even do a pre-suit mediation, before you even file a lawsuit. It's possible. Okay, and then David says, in a car accident involving 3 plaintiffs, can one settle earlier than the other ones? Yes, you could. Absolutely. That happens all the time. Like, for example, if somebody has a small case and they have, they want to take 10K, but someone else has like surgeries and they don't want to take like a small offer and they want to go to trial. So if one settles really fast and the other one has to wait years for trial. So that happens all the time. And then Dwayne says, good evening, Arkady. Can you do in-depth video on passengers in car accidents? Thank you. Yeah, sure. I mean, I don't know, what do you mean passengers? I mean, passengers are not obviously going to be liable. So if you have a passenger, it's good because you can sue both cars and whoever's at fault, right? It could be a rear end, so one car will be at fault, the other usually will not be. It could be a side swipe or different kinds of accidents, right? Side swipe, changing lanes where both people are a little bit at fault, or, so it doesn't really, I mean, what are you looking for with respect to passengers? Now, the good thing about a passenger, obviously, you're not at fault, unless you're like a passenger who grabbed the wheel and turned it. That doesn't really happen so often. So you're not at fault. So then the question becomes, what are your damages? And that's about it. So it's pretty straightforward. But I could do a video. Just let me know what specifically you want me to talk about. And then Manny also asks, can I send a life-changing story letter to my attorney and claim a quantity I need? Well, I mean, you could, but usually the attorney should be interviewing you and creating the life-changing story. It's like making a movie, right? Like if you have like a director like Martin Scorsese or whatever, whoever makes good movies, then that director is going to create everything, right? So they're going to interview you, interview your friends, your coworkers, your family, set scenes, like this is the first scene, this is the other scene. Sometimes you don't want to go in chronological order. Sometimes you want to go out of order, like Pulp Fiction, right? Start at the end and then go back to the beginning, then go in the middle. Make it interesting, right, for the jury. So you have to be creative. Like, you shouldn't be the one doing that. It should be the lawyer. But if the lawyer doesn't do that, then maybe, you could think about hiring a lawyer that does do that. I know a lot of lawyers that do that, like that create, human story, really get to speak to their client, go to the client's house, interview them, like today, for example, like I've been to my client's house. I've done many Zoom calls with her as well. And today what I did was I actually reached out to the school psychologist because when, her son, it goes to a certain school, and after she suffered a traumatic brain injury, she can't care for her son the same way that she could before. And one of the people that really know about that is the school psychologist. So I wrote her a nice email. I said, would you want to chat with me? And then afterwards, perhaps I could take your deposition, pre-trial deposition on Zoom, right? Just like this, record it like 20 minutes, 15 minutes. I'll just play that. So I don't want to bother her. I don't want to call her to court. She probably doesn't want to come to court. So things like that, right? But a lot of lawyers are not going to go that kind of depth. But that's what you need if you want the $1 million super duper result. So that's my opinion. Now, David also, we went through We went through David, we went through Dwayne, we went through Manny. Gatry says, is there a big difference in a cervical arthroplasty in terms of coverage? I don't know what you mean by in terms of coverage. Now, a cervical arthroplasty is a type of surgery. Coverage is insurance coverage, meaning like how much do you have? Like, for example, you could have $1 million or you could have 2 million or whatever it is. So I'm not sure where the connection is because one is a type of surgery and the other is a type of insurance. So the insurance is what it is, no matter what surgery you have or don't have. So I'm not really sure what you're asking. Okay, and then JC asks, Mr. Frekhtman, how are you? I have been trying to contact you through a number you gave me a while back, but it's only giving me automated replies. We have spoken a few times in the last few years. I don't know if you remember, I'm the young plaintiff who was injured at a concert, TBI and PTSD. I'm in the last stages of litigation, but there's a major issue I just found out about, and I'm very scared. I really don't know who else to go to other than you in your opinion. Is there any way I could speak to you any day you have some free time? Thank you, sir. Yeah, absolutely. Just text me 347-566-9595 and I'll call you I could call you tomorrow because I'm down until 6:11. I just have to do all this prep work. Like today I was prepping a neuropsychologist. Yesterday we prepped a neuroradiologist, the DTI and the MRI. So I've been very busy, but like I'll make some time. I'm still trying to do 1 or 2 consult calls a day, to stay so I don't, leave anybody without a consult. So yeah, just text me again. I'm sorry if I didn't get back to you. I probably missed it because I don't have anyone really. I think soon I'm going to set up a system. So if you text me, it's going to go to like a system where my whole office could see it. My office will follow up with you. We're going to have this software that's going to like really follow up with people. It's going to be better because right now it just goes to my phone, right? So if somehow I'm in court and I miss it and I forget, sometimes I can't really follow up. So, but I'm going to try to fix that. Okay, and then let me see. And then Manny also says, should I wait if the offer is low to see if the day before trial they come up with a real offer? Yeah, I mean, you could wait. It's hard for me to say. It's probably better for you to text me, or we could do another call, and I could give you the opinion over the phone, over a consultation. And then Kevin says, hi, Arkady, can I ask, do you only accept major accidents or soft tissue as well? I know some attorneys only accept major injuries. If they find out it's smaller, they usually refer out. Yeah, we do that too. We usually only accept major injuries. Like if it's really small, I usually refer it to a lawyer who specializes in smaller cases because you just don't have the time. You don't want to overwhelm yourself. You want to really focus on fewer cases, but doing a good job for the client. Okay, let me get back. Let me be back in 2 minutes. I apologize. I just have somebody at the door, so I just have to go down for a second, but I'll be back in 2 minutes. I'll leave this here and I'll be right back. Sorry about that. Oh, okay, I'm back. So let's go through the rest of the questions. Yeah, you can see all the trial binders. Those are like trial binders with medical records and other things. I think we have 6 of them. So I'm going through a lot of stuff. Okay, let me see. Which one were we up to? We did, I think Willie was saying, good afternoon, Mr. Arkady. So good afternoon, how are you? I remember, Willie, we had a nice consultation. And then Nico says, hello, sir. Hit by a commercial truck sitting at a red light. The driver of the commercial truck admitted it was his fault to the police. 3 rounds of injections and an RFA, which is a radio frequency ablation. And what do you think it's worth? So, I mean, a lot of it would depend on what city you're in, right? Because each city has their own kind of value range. Some cities, as I found out, like, for example, Virginia, it's kind of low. People were getting like 300,000 for a fusion, and that was considered the highest one. But in New York, people are getting like 5 million for a fusion, right? So like Bronx, right? So it just depends where you are. But yeah, I mean, injections, I don't know if you mean epidural injections. Epidural injections, I've gotten like 150,000, 140,000. RFA by itself, I'm not really familiar with the value by itself, because usually it's a part of something else. Like usually people have something else and then also the RFA. But I would think epidurals with RFA could be about 100,000, 150,000, something like that. Okay, and then Mr. Celine says, hi, who can change deposition dates? I have one today, but the lawyer says it's going to be next 2 months. Right, so a deposition is just like basically it's court ordered, right? So the court says do the deposition on May 21st, for example, right? But then the way they do it, at least in New York, is the day before you just call the other side and you say, are you guys ready? And then they might say, yes, let's do it. Or they might say, no, my lawyer is on vacation. My lawyer is on trial. My lawyer has a, whatever, sick. And then they just adjourn it. Or they might say, oh, we're not ready to go because we don't have this one authorization wasn't processed for ABC Medical. And we have to have ABC Medical. Otherwise, we'll just do the deposition. But then guess what? We'll have to take a second deposition once we get the records from ABC Medical, right? Because they want to have a full set of medical records to question you about your injuries. So you see things like that. Those are reasons it might get adjourned. And then usually it's just like the EBT clerk. When I say EBT, I'm referring to examination before trial. That's what they're called in New York. But in most states, they're called depositions. It's the same thing. But like a deposition clerk is the person that calls and says, are we going or are we not going? It's just like anything, right? If you want to have a meeting with your friend at the coffee shop, what would you do? You would say, which coffee shop, what time, and are we meeting? And then the friend might say, yes, we're meeting at 10 a.m. at, whatever, Roaster's Coffee, or maybe we're not because I don't want coffee, or I want to do it at 12, or I want to do it tomorrow. It's just like that. It's just setting up the meeting. So there's no real, if they really never do it, if there's 1 adjournment, 2 adjournments, make a motion and have the court compel them. And then they basically have to come, because if they don't come, the court's going to sanction them, and they're going to get in trouble. So but yeah, it should be okay. And then Shori also says, how much would a case involving a herniated disc, a pinched nerve, multiple soft tissue injuries, and post-concussive syndrome be worth? The plaintiff was a Philly Uber passenger. So you're in an Uber in Philadelphia and you have these injuries. These injuries usually, the injuries without the post-concussive stuff probably also, anywhere from, 30, 50,000, because you're talking about all soft tissue injuries. Now, post-concussive, if it goes away, it could be worth a little more, maybe 75, 100. If it doesn't go away and it becomes permanent, like a mild traumatic brain injury, then that's the case I'm working on now, right? Where I'm asking for like 7.5 million. It could be big. So that's going to be the big thing. And then I'd have to know whether Uber is at fault, because if Uber is at fault, then you have a bigger insurance policy with Uber. If Uber is not at fault, if the other car is at fault, I'd have to know how much insurance there is. Because you can go to court and get 7 million, right? But then if they have a 25 policy, where are you going to get the money? So those are the kind of things you have to look at. Okay, and then Noise Like Rambo says, have you ever gotten clients pre-settlement funding for the short term, like 6 to 9 months, to help them pay bills? And if so, is it usually for stronger high-value cases with clear liability? Yeah, clients do get pre-settlement funding. I don't, get it for them. They basically apply to outside companies. We could help, with the application. Usually the secretaries do that kind of stuff. Yeah, you could do that. And it doesn't have to be. Sometimes people borrow against smaller cases too. but usually it has to have some kind of value. Like usually, yeah, it has to be like at least a surgery or something, right? Because if it's complete soft tissue, the whole case is only worth 10K. So how much can you really borrow, right? If you borrow 1,000 and now the funding company wants, like, say 3,000 payoff at the end of the case, and the whole case settles for 10. Well, now the lawyer takes 3. There's only like 6, whatever, to give to the client, and now half the client's money is going to the funding company. The client's not going to be happy about that, but he only borrowed 1,000, and now he has to pay back 3, and half of the 6, right? Because it's 6, well, almost 7, 6, a third, and 2/3. So half of his money is going to the funding company, and the funding company doesn't want to be in that position either, because they want to be like at 10% of your money, 20% of your money, because they know you're not going to be happy giving away half your money to them. So you got to consider all those things. Okay, and then Zafraz says, hey, sir, how long after a case is certified for trial do you get a trial date in Nassau? Also, I was under surveillance, but I don't see anyone following me around anymore or around my house. Okay, so how long after you file the note of issue and certify as trial ready do you get a trial date? I think in Nassau it's about a year, maybe a little shorter. Even Nassau's pretty efficient. Other places like Bronx, it could be 3 years. Queens, a year or 2. Usually it's a little over a year in most places, but in Nassau it's a little quicker because it's like kind of a smaller area. The courts are a little bit more efficient. And then your second question about surveillance. Well, if you were under surveillance, what they have to do is they have to take the video and they have to serve or send it, usually the CD, to your lawyer, and then your lawyer is going to review it, and then your lawyer will advise you whether there's something on the video that's bad. Sometimes they do surveillance, they don't find anything. Like the case I had for 3.5 million, my client was hurt. He had a surgery from like C2 or C3 all the way down to T1, like 7-level fusion, and he had trouble moving his pinky finger because that's the dermatomes. Everything's corresponding, and I believe it's the C8 dermatome corresponds to the pinky. And he had like partial paralysis, but he could still drive. If it was just a pinky, he could still drive a car. So they videotaped him driving a car. Okay, big deal. Then he gets out of the car, he walks around, and he opens the trunk. He presses the button, the trunk opens, and he takes like a piece of paper, and then he presses the button again, and the trunk closes. Then he goes and he drives some more. I'm like, okay, who cares? Like, why? It's actually, I think it's bad for them, because you could say this is like an invasion of privacy. You're, basically somebody who's honestly hurt, and you're trying to catch them, and you're like invading their privacy and videotaping them, like for what? Like, what? I understand if you find something that's like damaging, like the guy's like, I don't know. I know one lady in like Switzerland or something, she was like in a tree throwing contest, and she was picking up trees and throwing them, and they were trying to see who could throw the tree the farthest, and she actually won. So that's an example of, obviously a fraudster, right? She's trying to say she's injured, but she's throwing trees. But if all they have is like that, right? Like a guy driving a car, we never said he couldn't drive, then who cares, right? And then the other one they did, which is a case that's still pending, was a guy who is so hurt that he doesn't even leave his house. So they knocked on his door, and he like opened the door, and he's like in his pajamas, like, what? And they videotaped him for a second, and then they closed the door, and they sent me that videotape, and I'm like, really? You want to use that at trial? Great. I'd love to cross-examine the videographer and everything. I'd love to discuss it. The guy's in his house in his pajamas. He's hurt. I mean, he can open a door, but that's such an invasion of privacy. You're videotaping him in his own house. Like, what are you doing? So great. If you want to use that tape, like, go ahead. The jury will probably punish you for that. So yeah. So videotaping is you just have to be careful not to do what you said in your deposition you cannot do. If you said you cannot do like X, right? Baseball, don't go and play baseball. They're going to catch. It's pretty easy. It's pretty easy. Okay. So we did the question about that. Now, Virgo asks, is it normal for a big company to not offer any settlement at all prior to a lawsuit being filed, even if the injuries are serious? Yeah, it's normal. Look, I have I don't know if you're like listening to what I'm saying. I have a case on for trial in a few days, and I'm saying it's a $10 million case, and I really believe it is. And they're offering me like $120,000, and they went to $250,000. So would they offer you $0 before you file the lawsuit? Of course. I mean, they're not fair. I have another case with a police officer who, he could never go back to work. He's only like 27 years old when the crash happened. I just went to the judge's chambers because the judge called us in and said, let's try to settle the case. I think that case is worth like 13, 14 million because there's lost wages that are like 7, 8 million, just wages, that are like quantifiable, and they're like millions. And then pain and suffering, let's say even if you go low on the pain and suffering, say it's like 4 or 5 million, but it's also a brain injury case. And the guy offered me $300,000, and his rationale was because he goes, and the CAT scan doesn't show anything, doesn't show a brain bleed, but he doesn't have that kind of injury. You don't have to have a brain bleed on a CAT scan to prove a traumatic brain injury. That was like a myth that was debunked in like the 1930s or the 1950s. I even told the judge that's from the 1950s. And he was like laughing at them. He said, yeah, I understand, but what can I do if that's what they're offering? So yeah, they're just not fair. Like you have to go to trial. That's why I think if that's the lady who has the case with the beer in the supermarket, I think I tried to find her a lawyer, but I don't know if you ever called the lawyer I recommended, because I think whoever she has is not a trial lawyer. So you're gonna be hard pressed. You're gonna need a trial lawyer who has record. You have to go to verdict search, and they have to have records of going to court and winning millions of dollars. Then that lawyer can go and win your case. Because if your lawyer is not a personal injury lawyer, doesn't go to trial, doesn't do jury trials, it's going to be almost impossible for them to get any money out of a big company. You need a trial lawyer. That's just essential. It's just, I don't know how else to explain it. Like it's not going to happen without a trial lawyer. Just filing a lawsuit is like not a big deal. You press a button and a lawsuit comes out. Like a software files it. It doesn't matter. They don't care. You have to go to trial, and when you go to trial, that's where they're going to start offering you big money, or you could take a verdict and then just enforce the verdict and get it from the jury. Okay, and then Larry says, hi, Mr. Arkady. I have a deposition in 2 weeks. How long would it take to settle, or how long would it take for them to make an offer after my deposition? It's a car accident in the Bronx, April of 2022. Okay, so if you have the deposition, there's not really any correlation between the deposition and settlement. They could settle before the deposition. I settle cases sometimes before I even file a lawsuit. One thing doesn't have anything to do with the other. Like a deposition is just part of the process, right? So you file a lawsuit, and then there's discovery. And one part of discovery, aside from exchanging medical records, is the deposition, where they ask you questions like what happened, what are your injuries? You answer the question. So the lawyer has to prepare you. Now, usually most cases do settle after the deposition has occurred, right? But I can't tell you how long after. The only person who can really tell you is your lawyer. And I don't know what posture the case is in. I don't know what the case is about. So that's more like, what the case is about, how it happened, what's the liability, who's at fault, what's your injury. That's going to be more or less. The fact that you're in the Bronx is good. Bronx is a good venue. I'm in the Bronx too in my case, but if you want, just text me, 347, let me put it in the chat, 347 566 9595. I'm happy to do a consult, answer your questions, then I could probably tell you more. Okay, JC says, thank you. You're very, very welcome. And let me see here. Skip ahead too much. Okay, Nico says, at a settlement, do I have to pay back the PIP and insurance companies who paid for medical treatment? No, you shouldn't have to. I mean, the PIP is statutory. So, like, for example, no fault, you have the no fault law in New York. That's up to $50,000. So if you get $50,000 of benefits, that's statutory, meaning there's a law that entitles you to $50,000 of first-party personal injury protection benefits. So it acts like health insurance. The car you are sitting in, let's say you have Geico. You're sitting in the Geico car. Somebody hits you in the rear. Geico pays for all your medical care, hospital, whatever you want, chiropractic, MRIs, up to $50,000. You don't have to pay that back. Yeah, no. I mean, I don't know how it is in other states, but that's how it is in New York. Okay, and Zafraz says, I have 2 more IMEs in July. I think the defendant wants to mediate the case after. Does it mean the case is going to settle? The demand was $3 million. Can I get close to that at mediation? No, I mean, I don't know. Has anybody listened to any of my videos ever? I'm sorry, but no, it's not how it works. I tried to explain it. I'll say it again. Mediation, do not go to mediation unless they give you a good faith offer, right? What they want to do is they want to bring you to mediation. It's almost like a spider, right? Think about a spider enticing you to come into the spider web. They want you to come into the mediation web. And then what they're going to do is they're going to tell you how bad your case is, why you're going to get a defense verdict, blah, 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 just to breed discontent and make you look at your lawyer and say, why the F did you bring me here? And then the lawyer's going to be all red and be like, oh, I can't believe this. That's what happens every mediation. What you need is, if they're really going to be serious and, talk turkey, if you want 3 million, then have your lawyer call them and say, I want 3 million. You have until April, not April, you have until June 21st, 2025 at 5 p.m. Pay me the 3 million. If you don't pay it, it's going to be 5 million, right? And if you want to go to a mediation, let's go. But give me a good faith offer. Offer me at least 750K, and then I'll show up to a mediation and we'll talk turkey. That's the way you do it. You don't just show up to a mediation blind. They're just going to offer you 20K. What's the point? It's just a waste of time. And then you spend $2,000 for the mediation, and then that $2,000 is going to come out of your pocket. It's just all a waste of time. Okay, Jennifer says, hi, Arkady. Why would a judge force a continuance of a mandated settlement conference if it's clear the defense won't make a reasonable offer? Why not just set a trial date instead of wasting more time? I don't know. That's up to the judge. Each judge does it his or her way. I can't really comment on that. It's hard for me to say. So it's a mandatory settlement conference, and the defense does not make a reasonable offer. Some judges think that a case may have a chance of settling. That's usually why they adjourn it, or maybe it's not up for the standards and goals. There's a lot of different possibilities. It's hard for me to say, but usually, so it's really hard for me to guess on that, but it's up to the judge. So eventually they will set a trial date. So they're not really going to waste a lot of time. They might waste a few more weeks or something. Okay, and then Jose says, is Denver, Colorado good location for settlements? I'm not too familiar with it. It depends on the type of case, but I think in general it's okay, because I know a lot of lawyers in Denver and they're very, very successful. Like one lawyer, I think, had some kind of burn case and he got like 20 million, and another lawyer that I know in Denver who's very, very good, and he's consistently getting big verdicts. In fact, I think he had one case where I think the total damages were like 45 million. So yeah, people are getting good results there. And then Sarah says, hi, I have an open personal injury in Wisconsin, I believe, right? WI, with a company that has a third-party insurance. I just found out I need knee surgery now from the fall. I will be having an MPFL reconstructive surgery with a TTO, which is a tibial tubercle osteotomy, is the TTO. Oh, I didn't even know that. So you learn something every day. That's good. Wow, that sounds serious. That's the medial patella. Is that the patella? The MP, I think that's the patella, right? MPFL. It's serious. Yeah. So you have an open injury case. I don't know what you mean by with a company. You have it against a company, and they have third-party insurance, and then you need knee surgery. So yeah, I think that's a big case. In New York, those kind of cases go for over 500,000, sometimes even over $1 million if it's like a total knee replacement or any kind of major surgery with open reduction, internal fixation, and they're putting in like screws, hardware, plates. Those usually are big cases. So yeah, I don't know about Wisconsin, but it might be a little less than say the Bronx or something. But I'm sure you could still get a substantial amount, like 6 figures or even 7 figures, which would be more than $1 million. Okay, and then Jason says, some name of a law firm. Any thoughts on big firms? Almost 3 years. I feel like I made a mistake. I can't really comment about specific firms, because first of all, I don't know them. I might have heard the name, but I don't know them. But the way I could do it is if you, text me privately the name of your lawyer. Like, for example, my lawyer is John Smith. If you need it, I could run a verdict search, and then I could email you back the results for like John Smith, right? All their past settlements, all their past verdicts, so that you have knowledge. And that's good to have knowledge as the client. It's you're the client. You want to know, does my lawyer go to court and get 0, 0, 0, 0 like goose eggs every time, and then one time maybe he got a verdict of 3,500, or does my lawyer go to court and get like 1,750,000, 2 million? You want to know. So I'm happy to send it to you, but it has to be done like confidentially, because I don't want like these guys coming after me like that. But I don't know these guys, but I do know lawyers in Colorado that are good. Like I just mentioned, one got like 20 million, the other guy got 45 million. Depends on the type of case you have also, and I could recommend someone for you to get a second opinion. And then Carl says, how do you counter defense arguments such as pre-existing or injuries not caused by the crash with your youngest of plaintiffs, given all medical treatment was followed and liability is established. Well, yeah, I mean, if you're young, then you shouldn't really have too much pre-existing. And then basically you just have them prove it, right? The way pre-existing works is they have the burden of proof because it's an affirmative defense. So they have the burden of proof to show that more likely true than not true, your injuries are not from the crash, but your injuries are from just having them before. So it's like they have to show that you had these injuries before. So if you never went to the doctor before, then you just show a timeline. You're like, look, I never went to the doctor. I'm a young guy. I'm like 22. I haven't been to the doctor in like 5 years. There's no medical history. Then I have this crash. And then all of a sudden, look, hospital, urgent care, MRI, X-ray, chiropractor, physical therapist. And it's like, blah, 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 you know. And then, wait a minute, how can you say that I had this before? I didn't have anything before. Prove it. And if they can't prove it, beyond more likely true than not true, or the greater weight of the evidence. The greater weight of the evidence has to be on them that it is pre-existing, right? If they can't prove it, then just call them out and say, why are you even bringing this up? This whole thing is a frivolous defense. People talk about frivolous lawsuits, right? Well, how about frivolous defenses? If you can't even prove it, why are you bringing this up? Just to try to prejudice the jury? And then call them out and just fight them and send them home, you know? And then and besides, look, even if you have a pre-existing condition, you're entitled to get compensation to the extent that that pre-existing condition, whatever it was made worse by this crash. The only way you get nothing is if they can show you had a pre-existing condition. The crash happened, nothing changed. You have the same exact condition after the crash that you had before. Then you get nothing, right? Because the crash didn't do anything. But it's very hard for them to show that. So you can have whatever condition, it just makes you more vulnerable. And now they have the crash, the fall, whatever the incident was. Now your condition is made worse, and that's called an aggravation or an exacerbation, right? Aggravation, exacerbation. Now you're entitled to recover to the extent that it was made worse. So you show, like, for example, I had a bulge before, but I just had a bulge. It's on an MRI, but I was playing baseball. I was fine. Didn't bother me. Didn't affect my activities of daily living. But guess what? Now I had this crash, and now I need a surgery for the bulge, right? So that's how it was made worse. So how could you say it was from before? It's really easy to beat if you know what you're doing. Okay, Jose then says, I received a lumbar fusion after 5 epidurals due to a collapsed ceiling in my apartment. My lawsuit has been filed and we are in the discovery phase. The insurance company has hired, and he gives the name of a firm. I can't really discuss firms too much, but are they a fair firm? Oh, you're saying the defendant? Are they a fair firm? I mean, I see who you wrote. I know them. Yeah, they're fine. They're just like another defense firm. I have them on cases right now. A lot of cases with them. I settle cases with them all the time. They're fine. There's nothing, they're all the same. The other defense firms. I don't really see much difference between any of them. And then how long do you think before they try to settle? It's a clear negligence on the landlord's behalf with plenty of evidence. Well, remember, they never try to settle. Your lawyer has to litigate the case aggressively and put them in a position, put them in a corner, and then tell them, hey, pay me X, and if you don't, then it's going to go up. But, I don't know. I don't know who your lawyer is. That's the key thing. So just text me privately if you need a consultation. It's 347-566-9595. And I think I dropped it in the chat as well. But see, yeah, that's the main thing. Now, if you had a lumbar fusion with a ceiling collapse and you said you're in Connecticut, that could be a big case. That could be like a $5 million case. If you need a recommendation for a Connecticut lawyer, I actually was starting to work with a firm that it's amazing. They had a $100 million verdict in Connecticut. They're actually out of Las Vegas, but now they're in Connecticut as well. And like I said, they had a $100 million verdict in Connecticut. I think the last verdict they took they do cases nationally. They did a big case. I think I did a video about it. They did a case out of I think it was New Mexico. They got $400 million. And then they consistently get cases in Las Vegas for 30 million, 20 million. They're actually the firm that does the research where they have thousands of people in a focus group. And then they present the facts of the case to people. And then they get thousands and thousands of responses. And then based on that data, what they do is they then estimate what the case will be worth. And I was talking to the owner of the firm, the head trial lawyer, and he was saying it's uncanny how accurate it is. For example, it tells you ask for 20 million and you're going to get 16. And so he asked for 20 million and he gets 16.5. It's and he knows exactly what's going to happen. It's insane. So yeah, if you need a recommendation, I'm sure they would help you with a fusion case. But you may have, I'm not saying you have to, you might have a good lawyer, you could stay with your lawyer, but I don't know. So if you text me the name, I can also do the verdict search and send you the results. So if you have somebody that already gets like whatever, 5 million, 6 million, maybe you want to stay with them. But maybe you have somebody who gets like 0 or who's never even been to court or doesn't even know where the courthouse is. That's not good. That's going to mess everything up. So I don't want you to be surprised later on. Okay, PO says, does the jury consider multiple herniated discs or do they lump them all together? No, I think they do. Again, it depends on the lawyer, right? You have to present it in a certain way. You have to be persuasive. You have to know the medicine. But no, I mean, if you have multiple herniated discs that are caused by the crash, it shouldn't be lumped all together. It should be compensation for each one. And then Only Pure says, the defense filed a motion asking for more time. My lawyer did not disagree, and the extension was approved. I'm so mad now. Our trial date is canceled. We'll get a new trial date in July. Oh yeah, I'm sorry to hear that. I mean, you don't want to get delayed. It seems like the big thing, just from doing these videos and listening to people, the big thing is how much am I going to get and when am I going to get it, right? Nobody wants to wait and nobody wants to get lowball. And yeah, I mean, in this case, you're getting, you're being made to wait, and I don't know why your lawyer agreed if it wasn't justifiable. Okay, and then Corey Dip Vevo says, good day. Do you know if my case is on the right track? I have another surgery Wednesday and 2 more surgeries after that, in a total of 5 surgeries and a ceiling collapse last year in August. Arthroscopic knee surgery, both knees, ACDF, arthroscopic left shoulder, and decompression in the S1 lumbar back. Yeah, I mean, it sounds like an amazing case, but I don't know if it's on the right track or not. The only way I could know is if you text me. We could do a consultation. I could help you. But, I don't know, right? You could have a case like that, and maybe he didn't even file a lawsuit, or maybe you have a billboard lawyer who never goes to court, or maybe you have the best lawyer, I don't know. How can I know? The best way is just to text me. We could do a private consultation, and we could discuss all of the issues. Okay, and then Burns says, just finished my second deposition last week, Monday, and we are scheduled for trial in November. The case has been going on for a while. Highest offer so far has been $25K. Do you think State Farm will have another offer or just go to trial from your experience? So you finished your second deposition and you have a trial in November. I mean, probably they will offer more. I don't know what your injuries are. I don't know what the limits are. But if they offer $25K, it's something. But again, you gotta, the main thing is the way that you present the case to State Farm and the way that you litigate the case. So if you do it the right way, you pretty much give them everything, right? All the medical records, all the human story, photos, whatever you have to show your damages, witnesses. And then you say, look at all my evidence, pay me whatever. Let's say it's 100 policy, pay me the 100. You have until X, June 21st. If you don't, that's fine, but it's going to be 500. And if they only have 100, they don't want to get exposed to 500. So then they'll just tender the 100. I just did it with State Farm. They tendered the 100 to me. But if your lawyer doesn't do it that way, if he does it the old school way, I have a demand of 100. They're like, oh, that's too high. How about we give you 25? Okay, now I have a demand of 75. Now I have a demand of 50. Well, guess what? Now he just lost you 50K because now the most he could ever get is 50 because he's demanding 50. So you can't demand 51. You can never go back up. So it just depends on how they do everything and whether they're doing it the right way or not. I don't know, right? Some lawyers do it the right way, some lawyers don't. And most lawyers do it the old school way, which is like the demand and everything. I don't even like the word demand. I never have any demand. My only demand is a jury trial. So, I just do it like my way. Well, not my way, but like the way I learned, more of a new school way. Okay, Only Pure says, how long after an IME exam are settlements negotiated? Defense is stating after IME would like to talk settlement. Yeah, so again, there's not really any rule. There's nothing. You could negotiate a settlement before you even file a lawsuit. There's not like 2 weeks after the IME, that's when settlements are negotiated. It's not like that. It could be done at any time. It's not like skiing, right? You could only ski in February. You can't ski in July. You could negotiate settlements anytime. Whatever they're saying is just what they want to do, basically. You could say what you want to do. So, but usually, I mean, from my experience, usually after an IME, that's what, if you've had depositions, you're on the trial calendar, that's usually when most cases do settle. But again, your lawyer should be the one doing everything, sending the letter, doing it the the settlement opportunity, and if they don't pay, go up. Like, otherwise, waiting for them to make you an offer, they might say never, right? Why would they want to make you an offer? These insurance companies, they make like $93 billion a year. And what they do is they invest their money into like hedge funds and stocks and whatever they do, like options trading, and they're making even more money because 93 billion is a lot of money. And then they can make like 20 million a day. I don't know, maybe more. I don't know how much they make. But why would they want to take the money and give it to you, and then they can't make the money in the market or wherever they make it? If they don't have to, so you have to force them to. That's what I'm trying to explain. So I wouldn't just wait for them to do anything. Okay, and then Nene says, "Good afternoon, Mr. Frekhtman. What usually happens at a settlement conference?" Yeah, so it's just they talk settlement. They say, "What's your demand?" That's the word they use, but I don't like that word. Meaning, how much do you want? It's the same as saying, "What do you think the case is worth? What's the value?" Right, for the plaintiff. Then the defendant gives the plaintiff says, "I think it's worth $1 million." Defendant says, "Oh, I only have 50,000." Okay, step outside, Mr. Defendant. And then they start talking to the plaintiff. What do you really want? Are you really at $1 million? Would you take less? Okay, judge, yeah, $1 million is my official demand, but I would take like 300,000. Okay, step out. Now they talk to the defendant. Oh, you're only at 50? Can you come up? I think we can get this resolved, but not for 50. What's your best? Okay, let me call the adjuster. Let me get more authority. Okay, I can get to 125. And then they have you step in, and then sometimes they'll talk to both of you and then see if they can, basically get you to a middle number. If they can, great. Everyone's happy. You sign a settlement, you get your money. If not, then just, the top offer they made, and the how far down you went if you're going down, if that's your negotiating strategy. I don't like to go down. I just stay wherever I am. But some people like to go down to get them to come up. And then basically you just leave off to wherever you were. Like if you left off at 700 and they left off at 125, then you're still far apart. And then they say, okay, I'll give you a trial date. So then when you pick a jury, you could talk again and try to settle it then, or you could just say, you know what, we're too far apart. We have to get a jury trial, the jury decide. Okay, so Jason says, LMAO, some watch most your videos. Thanks for your patience with all of us. Oh, thank you. Yeah, I'm sorry. Sometimes people ask me questions, but I've said that 1,000 times before, so I'm like, how can you? But yeah, I guess somebody maybe is a new viewer. Okay, William says, Arkady, thank you so much for everything that you do. We really appreciate you. As anything that we can do for you? Yeah, well, one thing I would ask, if I've given you a consult, or even if I've talked here, if you can maybe leave us a review, that's really helpful, because when we have reviews on Google, we have 6 offices in New York City. So we have Bronx, we have 2 in Brooklyn, we have Fulton Street, which is North Brooklyn, and Bedford-Stuyvesant, and we have this office, which is Bensonhurst. This is 60, Bay 26th Street, which is Bensonhurst, South Brooklyn. Then we have Queens in Metropolitan Avenue, Forest Hills. We have Manhattan on Broad Street, I believe we have one downtown, and we have a Manhattan one in Midtown in near Rockefeller Center. So basically, if you find it on Google, I think we have a link in the description of every video, and it basically says either leave a review or give a review. And then if you click that link, it should have the link so that you could leave us a review. That would be helpful, because what the reason, and not because I'm asking for reviews, but because the reason it would be helpful is because then clients, right, potential clients that are looking for lawyers, the more reviews you have, they would then see us, we would be more prominent, and they would maybe call us rather than calling one of those billboard guys that are paying people in India to write fake reviews or whatever. And then those billboard guys, they don't go to court. So then people hire the billboard guys, and then they get screwed, but not right away. Maybe they get screwed 2 years later. But this way you'd be doing a good service and you'd be helping us. So that's one thing. And also just like and subscribe to our channel. But no, thank you. I really appreciate that. And then Billy says, are you likely to settle at a required mediation if the case is worth more than the 100K policy? 2 herniated discs, a hand tear, and PTSD with over 30K in medical bills. No, it depends on how much the policy is. But if you have PTSD, I've done videos, PTSD is as valuable as a TBI. That could be worth millions if the coverage is there, right? Or you could set them up for bad faith, depending on what state you're in. So yeah, you don't have to settle out of mediation. A mediation is non-binding, meaning it's just an attempt to talk about the case, negotiate the case, and see what the offer will be. But there's never any obligation to settle. The only thing that's required is that you go to the mediation if it's a required mediation. And the only reason that's required is because it's a court-ordered mediation, so they want you to show up. But you could just show up and say, my demand is a jury trial, and that's it, and then you just leave. You don't have to negotiate with them, especially if they're really low. So no, I wouldn't worry about that. I mean, especially if you have a tear in the hand. I mean, a tear in the hand, I've settled for like 175, 200,000, and PTSD is a big injury. So no, I wouldn't settle for like 30. What are they offering you? If the case is worth more than, it's worth more than the 100K, all they have is 100K. So just tell them to tender. Send them a letter. Tell them tender the policy. And if you don't, see, what I like to do is, this is what I do. I send them a letter. My letter is long. I can even send people, if people need a template, I can send a sample. My letter is long. It's like 15 pages. Each letter is different, but it has some of the same circumstances. But one thing that I really like to do is I like to say, look, all you have is 100,000. Now look, I have past pain and suffering from the date of incident until now. It's usually like 3 or 4 years. That's worth like 100,000. Then I have future pain and suffering from the date of incident. I mean, from the date of trial, right? Whatever trial will be like in 2026 for the rest of their life. And that could be like 50 years, right? People live to be like 83. And there are averages that tell you what, the statistical averages. People live to be like 83. And my client's only like, 30 now. So that's 50 more years of pain and suffering, right? What's that worth? Okay, let's say it's worth low, conservative, but it's still worth like 300,000, right? Or you could say how much per year if it's worth like, if it's 50 years, even if it's 10K a year, it's 500,000, right? But no one is going to go through a life-changing injury for 10K a year. It's not even anything. It's not even a salary or anything. So, you just do it like that. And then you say, what about lost wages? And you add money for lost wages. That could be like 50K or whatever. What about future medical expenses, like future surgeries, future MRIs, future prescriptions? That could be like 200K, or sometimes it's millions. And then you add everything up, and usually it's a big number. It's like, like the last time I did it, it was like 3 million something, and all they had was 100K. And I was like, okay, so then I have 3 million here, and you have 100K. So isn't it clear you have to give me the 100K? So that's the way I do it. But that's the way I recommend. Your lawyer probably should do it too. But some lawyers write demand letters just saying, I demand like 50K, and that's it. It's like, okay, they're like, okay, thanks. You're asking us for money, and they throw it in the garbage. And there's no there's no teeth to it. You're not putting them in a corner. You got to put them in a corner. Okay. And then Sarah says, the company that I was working for doesn't have workers' comp insurance. They have a third-party insurance, and they already accepted medical liability. I think their policy is 1 million. And yes, that would keep knee surgery involving hardware and screws. Yeah. So, I mean, those are big cases. Oh, so it's like a work comp case, but also have personal injury case against the property where I fell while I was working. Right. So my understanding, I don't know how it is in like Wisconsin, but in New York and places, my understanding is workers' comp just pays for wages, lost wages, and also for your medical bills. And then the third party action is to get money for your pain and suffering. So that's where the big money is the third party action. The workers' comp is just like insurance pretty much. Because if it was like a car crash, no fault would pay, right? But because it's a work incident, they pay the carrier. There's usually a worker. I know you said there's no insurance, but usually there is. It's known as a workers' compensation carrier, insurance carrier. And what they do is they pay lost wages and medical bills. And then Shori says, can acupuncture and cupping count as medical expenses if injuries do improve from them? Yeah, I guess so. If it's medical, it's a medical expense. But why would you care if it counts or not? Like, you don't really want, I mean, I usually, if it's a small case, I waive medical expenses. You don't want medical expenses to be like a low anchor, because if you're doing acupuncture, it doesn't cost much, right? So they're going to say, okay, you have medical expenses of 10K. Let's give you 3 times 10K, 30K. But if you don't say anything and you just say, look, I have a painful herniated disc, and you explain the medicine and it's touching these nerves, and I might be, whatever, I might have problems later, I might need a fusion, now you can ask for 3 million. Why would you want to low anchor with the medical bills? So I usually just forget about the medical bills. Okay, Sarah says, thank you for your answers and insight. Very much appreciated. Oh, you're very welcome. And then he says, how do you view Philly as a case venue? Philly's good. I like Philly. Philly, a lot of big verdicts in Philly. Just Ride says, can you still go after the access umbrella if they're surrounded the policy limit and sign the settlement? So you mean if you already signed the settlement? No, then it's over. Then you're going to get whatever you signed for. But yeah, like you could get excess umbrella. You just have to find out what it is. And then when you do the settlement letter, you include that. Like my case is 1 million, right? But they have 5 million excess. So that's why I wrote 4,750,000. And they had a chance. They had a chance. They could have saved 1.25 million. but they blew it. Now it's 7.5. They don't have 7.5. All they have is 6. But I don't care. I'm just going to go. I'm like a train. I just go. That's fun. I like to watch them squirm. Oh, the lawyer who attended, I actually wasn't able to attend on Monday, but the lawyer who attended said the defense lawyer shows up and she's all upset. Okay. I mean, I'll show up. I'll be super nice. I'm super nice. I don't want to make anybody upset. But I don't know why people get upset about, they get upset about paying out money, but how come they don't get upset that like somebody, like a human being has a brain injury for the rest of their life or has PTSD for the rest of their life? I would be more upset about that, right, than about having to pay money. But they only get upset about money. That kind of shows their true colors. But anyway, that's a different story. So let me go do a few more questions. How long does it take to gather documents and send them to the insurance company? Life with Val. Well, it depends what documents you're talking about. I mean, if it's like a settlement letter, you already have them because, you know, you're sending the letter usually like after discovery is done or towards the completion of discovery. So you have all the medical records, you have like photos, liability, experts, and you just put it on a letter. You know, usually I do a long letter, like 15, 20 pages, send it out, you know. Alberto says, hi, Mr. Arkady. My question is why funding for a surgery can be denied? The firm that's with another company or other options? Yeah, I mean, well, funding for a surgery basically is up to the funding company. So you have to ask them why it's denied. I wouldn't know, right? The way it works is the funding company has their own underwriters, and those underwriters include lawyers that are familiar with personal injury. So it might be because you borrowed money before and they feel like the payoff is too high. Because remember, they only want to be at 10% of what your total will be. So if your total is going to be $1 million, you're going to take home 700,000. They don't want the payoff to be more than 70, or maybe a little more, like 80. But they don't want to take like half your money, right? Because then you'll be upset and you might go to a judge and say, who are these shysters who are taking half my money? And the judge might agree, and then they won't get their money, and then it'll be a whole lawsuit about the funding. And they don't want that. They know that could be an issue. So they want to be at like 10% or less of what you're eventually going to get. So that could be one reason. But you have to really ask them. They'll just tell you. Okay, and then Jennifer says, just want to say I had no idea that some personal injury lawyers were not trial lawyers. Such an important piece of information for injury victims seeking representation. Yeah, exactly, right? Because if you're not a trial, it's like saying, like, I'm a surgeon, right? Come to me, but I've never operated before. But just come to me, and then I guess if I have to cut you open, I'll send you to my friend or whatever. I mean, it's crazy. But yeah, most lawyers are not trial lawyers. There actually are not that many trial lawyers. It's a real skill and art, and you have to have experience doing it. And like, for example, Richard in my office, he's been trying cases since like the 1980s. He's probably tried hundreds of cases. I haven't even tried that many. I've maybe tried like 30. But now I'm trying more. Like during that year, right before COVID, I think I tried like 9 cases that year, and I'm trying to try 4 or 5 every year since then. So, and then some lawyers have tried like 200, like the guy who got the $50 million verdict against Starbucks. I think he's tried like 200 cases now. So it's just a matter of experience. And Gary says, good evening, my Arkady, my case going on from 2023, a rotator cuff injury, no surgery, 3 injections, happened in New York. How much is my case worth? So rotator cuff, it depends if you had surgery, injections. Again, if you mean, no surgery, right, it says. So rotator cuff without surgery, I've settled those for like 75. Injections, I mean, if it's epidural, I've settled those for like 150. So together, if you add 75 to 150, what is that, like 225? So it could be something like that. Depends on how much the policy is also. And Nene says, if you take loans out before you settle, can you get loan forgiveness? I've been waiting since 2022 and my injuries are severe, which interferes with me keeping a job. No, you can't get loan forgiveness because it's not a loan. It's non-recourse funding. So the way it works is when you take a loan, you call it a loan, but it's not a loan. When you take money against your case, what you're doing is you're selling a portion of your case to the funding company. Meaning you're giving them a piece of the pie, and you're giving them that piece of the pie that's equivalent to the amount of money you're borrowing plus the interest that's in the contract. So for example, you have $1 million case, right? And you borrow 10K. Well, some companies will say, okay, the most you'll ever pay back is 30K. So now you've sold 30K to them. So then when your case settles, $1 million, the lawyer takes a third, there's like 700,000 approximately, 666 or whatever for you. So then out of the 666, they just deduct the 30K, they pay the funding company, and then you get the rest, right? Instead of 666, you get like 630 or whatever it is. You know what I mean? Like that's how it works. So you can't you can't ask for forgiveness. What you could do is you could have your lawyer call the funding company and say, look, I don't want to pay, like, say, 30K, can you make it like 25? They'll sometimes do that. They'll lower it for you, but because it's not a loan. Because if you say tomorrow, I don't want this case anymore, you know what? I'm just going to move to like Thailand, or Bali. I'm going to move to Bali. I'm just going to live on the beach. I don't care about this case. Screw this case. I'm getting on a flight, and then the case gets dismissed. You never have to pay that 10K back. It's your 10K, and they have no recourse against you, because that's why it's not a loan. What you're doing is you're selling a piece of the case, of the lawsuit, to them, but they only get it back if the lawsuit is successful. If you say, I don't want the lawsuit anymore, the lawsuit gets dismissed on a motion for summary judgment or whatever happens, right? You pass away. I mean, a million things could happen. And then all of a sudden they have no recourse. So that's why it's a risky business. That's why they take high interest. So I hope that helps to explain it. Okay, and then Shores Skies, my guy, says, how much is white matter changes in the brain which could be linked to the herniated discs and car crash, which also causes a pinched nerve, giving radiating pain, and there is tinnitus and eye issues? I mean, it's hard for me to say based on that. That's very general, but white matter changes are pretty serious. In fact, like the case I'm handling now, the two cases I mentioned today, like the one in, both of them are in the Bronx. One is a car crash and the other one is a slip and fall. They both have like white matter changes on a diffusion tensor imaging. White matter is basically the way that you have gray matter in your brain. That's where all the neurons are. And then underneath that is the white matter. And white matter are like tracks, right? Like train tracks. And that's how, for example, the neurons communicate with each other. They travel along the tracks, like the impulses. That's the white matter, right? So diffusion tensor imaging, it's known as fractional anystrophy. What it does is it examines microstructurally the brain, and it finds, like, okay, this is how the track should be, a proper track, because the water molecules move along the track. And now all of a sudden, wait, you have a hole here, and it shows the hole. So it's a color, it's like yellow and red and green, and then it shows there's a hole here, so the track is not, it's not working. Basically, there's a hole in, like, if you look at it like train tracks, there's a hole in the train tracks. The train can't get from here to here. So that's why. So if you have a thought, for example, I have a thought, I want to, eat an apple, and then you think, I want to eat an apple. Then you have to pick up the apple. You have to bite into the apple. Well, it's not going to work if there's a hole in the track, and that's the white matter. So if you have real white matter changes, you're going to need a neuroradiologist. You're going to need a neurologist, neuropsychologist. But that could be big. That could be worth millions and millions. Those are huge injuries. And the other injuries you mentioned are smaller, but they can have a value as well. And then the machine says, hi, Mr. Arkady, my trial was removed from the calendar due to pending lower back surgery. After the surgery has been approved, how long does it take to put my case back? It's not really long. You just file a motion, it gets restored, and that's it. And it goes back to the same place it was. So you don't start at the end of the line, you start wherever you were in the line. So you just make a motion or you sign a stipulation. It doesn't take long. Just file a motion, maybe a few weeks, and then the judge will decide. Or if they agree to stipulate, they can stipulate. And then Sandy says, hey, Arkady, nice to see the live stream again. Oh, thank you. Yeah, Sandy's a nice client. He's somebody we just settled a case for, a really nice guy. And he had a car crash case, and we settled it. We were able to get him good compensation. I wanted to get him more, but he couldn't wait, so it's okay. But I think he's happy with the amount. And then Faro says, what happens to my insurance if the passenger is suing me and I'm not at fault? Well, then nothing happens. If you're not at fault, why would anything happen? I mean, the fact that they just sue you, anybody could sue anybody, right? You could sue, like they say, you could indict a ham sandwich, right? You could sue anybody, but what's the difference? If they're not at fault, what difference does it make? Just explain to the insurance company, I didn't do anything wrong. I'm stopping at a red light. The guy rear ends me, but the passenger sued me. Your insurance is not going to go up. Nothing's going to happen. And he says the other driver has no license, and my dad has insurance driving his car. Well, I don't know. I'd have to look at the whole case, but I wouldn't worry about anything happening to you. Just send it to your insurance company. Let them deal with it. They shouldn't raise your rates or anything. Okay, I have to run, but please like and subscribe to our channel. One thing, like, I'll ask again, because now I see we have 61 people, is if you can leave us a review in every video description. If you go to description in any video, it should have a little thing like give a review or leave a review. That's going to help, because that will, if we've done a consult, or if you find like help from these consults when I answer your questions, you can leave us a review. I think the rule is if we provided some kind of value or give any kind of consultation, you're allowed to do it. I would ask for that just because I think that it would really help the public, right? Because then we become more prominent in the Google listings. We have listings in like Manhattan, Brooklyn, Bronx, all over New York City, as opposed to the other people. And then, if clients need a lawyer and we take their case, we can actually help them. You can see I go to court, as opposed to one of the other guys that's just going to say, take 20K. If you don't take it, then, it's going to go to 10K, which is not true. That's another thing. Let some lawyers say, they kind of strong arm clients and say, hey, you have to take 20K because that's what I have. They want the money. And if you don't, then they're going to withdraw the offer. That's never true. They never withdraw offers. They never lower offers. They only go up, but lawyers lie and get people to take lowball offers. So it's not right. Okay. So have a great night, everyone. And I'll do another video maybe later this week, or maybe even like tomorrow or Friday. I'll try to squeeze another one in, and next week as well, because like my trial's not until June 11th, but I have a lot of other work. But I'm going to try to get to everything and get up to speed. Okay, have a great night. Thank you so much. Like, subscribe to our channel, leave us a review if you can, and all the best, everyone. Okay.